Hey there. If you've been injured in Scotland, you need to listen up. We're about to break down something absolutely crucial, the massive differences between Scottish and English law. And trust me, getting this right is everything when it comes to your compensation claim.
All right, so let me ask you something. You get injured in, say, Glasgow or Edinburgh. What do you think? That just general UK law covers your claim, right? It sounds logical, but that's a mistake. A really dangerous one, actually.
And look, I'm not trying to be dramatic here, but the reality is, getting this wrong could cost you your entire claim. We're not talking about some minor technicality. This is literally the difference between getting the compensation you deserve and walking away with absolutely nothing. Okay, so first things first, we have to bust a huge myth. This whole idea of a single UK law for personal injury, it's just not true. You see, the UK actually has three totally separate legal systems. And Scotland's system? It's been its own thing for centuries, way before the Act of Union back in 1707. So why are they so different? Well, it all goes back to their roots. Think of it like this. Scottish law grew from the same soil as many legal systems in continental Europe. It's based on Roman law. English law, on the other hand, grew on a completely different island, based on something called common law tradition. This isn't just some dusty old history lesson. It means the two systems have completely different DNA. They think and act in fundamentally different ways. All right, now let's get to probably the single most critical must-know difference. This is the one that can trip up pretty much anyone making a claim. I'm talking about the deadline, the time limit. Let's call it the 3-year countdown. 3. Seriously, if you take away only one thing today, let it be that number. For most personal injury claims in Scotland, you have exactly 3 years to get your case to court. And when I say it's a strict deadline, I mean it is incredibly strict. Yeah, this isn't some friendly suggestion or a guideline. It's written into law. It's called the Prescription and Limitation Scotland Act 1973. And pay attention to the legal word they use, extinguished. That's so important. It doesn't mean your claim is just put on hold. It means it's gone, poof, vanished, forever. So here's how that works in real time. The second your accident happens, a stopwatch starts, and it's ticking. You have exactly 3 years to get that case filed in court. If you miss that deadline even by 1 day, it's over. It doesn't matter how solid your case is. It doesn't matter how severe your injuries are. Your right to claim is just gone. Okay, so let's say you're on top of the deadline. Great. But now what? Where does your case actually go? Well, that brings us to another huge difference. The court system in Scotland is a whole different ballgame. Just look at this breakdown. In England, you're probably heading to the county court, but in Scotland, you're going to the sheriff court. And for the really big, serious cases, England has its high court, while Scotland has what's called the Court of Session. The names might sound kind of similar, but don't be fooled. They are totally separate worlds, with their own rule books and their own way of doing things. And, the amount of money you're claiming makes a big difference too. If it's a really significant claim, say over £100,000, your case will likely end up in the Court of Session in Edinburgh. That's the big league, Scotland's top civil court. You're dealing with judges who are specialists in complex injury cases. It's a completely different atmosphere than you'd find down south in the English High Court. So, we've talked about the clock and the courts, but the differences go even deeper. The actual laws that apply to specific types of accidents are also totally unique to Scotland. And this, right here, is why that generic UK-wide legal advice you see on the internet can be so dangerous. I mean, just look at this list. A fatal accident claim? That's not just a general claim. It's handled under a specific Scottish law from 2011. Got injured by an animal? Bam! There's a Scottish Act from 1987 just for that. Even medical negligence is different because NHS Scotland is a completely separate organization from NHS England. Every single one of these situations needs a legal expert who is an absolute specialist in Scots law. Okay, wow, that's a lot to take in, I know. So the big question is, what do you actually do with all this information? Well, don't worry, we can boil all of this down to a really clear, simple roadmap to make sure you protect your rights. Here it is, 3 simple steps, and honestly, these are non-negotiables. Number 1, that 3-year time limit, treat it like it's written in stone, because it is. Don't put it off. Number 2, make sure, and I mean make sure, your solicitor is a true expert in Scots law, not some big firm that just has a Scottish desk. And number 3, be suspicious. Question any advice that claims to be UK-wide, because as we've just seen in the world of personal injury law, that's almost never the case.
So there you have it. What looks like it should be a straightforward process is actually governed by a completely unique legal system with its own rules, its own courts, and its own deadlines. So the final question to leave you with is this. Now that you know, are you really prepared to navigate it the right way?